Hello, I want to welcome our viewers from across the United States and around the globe. You're in the National Security Clearance Situation Room of the Edmunds Law Firm. I am attorney Alan Edmunds, the owner of the firm, and my firm has offices across the United States for your convenience. In the previous videos that I have done, I've tried to introduce you to the dangers and to the risks that confront you when you get a statement of reasons. I've even discussed specific guidelines in the directive which I am holding. 5220.6 and 704 are directives that list concerns that the federal government raises concerning your behavior and why the government thinks that you are a risk to national security. Of course, the directives also contain mitigating factors. And my law firm prepares trial notebooks, and we vigorously oppose government actions to revoke and deny security clearances. I can't tell you how important it is for you to come into court with an experienced expert to fight for your family, to fight for your paycheck, and to fight for your career. You see, you only have one chance. And if you leave the courtroom and say, I never realized how serious the government was going to attack me in court. I never realized how ill-equipped I would be in the courtroom to answer questions. Or I never realized that I didn't come to court prepared. And now you've lost your job. It's done. You have to look for a job that doesn't require clearance because you're not going to be reinstated for years. So today I want to talk about a specific guideline that is becoming very popular by the federal government in taking people's clearances, and that's Guideline G, alcohol consumption. And the concern is that individuals have demonstrated excessive alcohol consumption either currently or in the past. This can include DUI convictions. It can include public intoxication, or it could include reports or complaints by coworkers or spouses or third-party individuals who file a complaint or simply call your employer or the Department of Defense to complain about what they think is alcoholic behavior. One of the biggest and most frequent cases that we get involves DUIs that are years old. You can have a DUI or two DUIs that are 5 or 10 years old, and the government today will file a statement of reasons alleging those two incidents and seek to withdraw your clearance. It's very, very difficult to win if you're not prepared and not experienced enough to know how to respond. My law firm will assign a team to you as a client. There will be one national security paralegal, one national security attorney, and they will work with you on a constant basis to prepare you and your witnesses for court, and also prepare a trial notebook. We go beyond that though. If you look at our websites and scroll through the cases that we've won, you'll see that we know how to win. Many attorneys have slick websites and say they can win, but when you check on the official government websites under their name, you'll see little experience, or in some cases, none at all. But their website says they can help you and that they're experienced, so be a smart consumer. Guideline G is becoming a very, very important guideline, and The government is using it more and more frequently. There are steps to take to mitigate the Guideline G allegations. Some of those steps require weeks of preparation. Maybe my firm will send you to an expert, or maybe we'll have you engage in certain activities that would mitigate the concern. I can prepare you for the questions that the court is going to ask. I can prepare you for the questions that the government attorney is going to ask. And when you leave the courtroom, you'll be like hundreds of our clients that look at me and say, I could never have done that without you. Go to my website, read the testimonials, and if you get a statement of reasons, please don't answer it yourself. And please do not waive your right to a formal hearing. I look forward to your call. Thank you.